All right. Hopefully everybody can see and hear me as you start to sign on. We've got about a minute before we officially get started on this. As people are joining, let me know that you can hear me okay. We've got a different microphone here that's being used, so I want to make sure that everyone can in fact hear me. Obviously, I think you can see me, but we've got a special guest coming on later today. So we have them via Zoom. I want to make sure that we can actually work this appropriately. I've got Mario behind the scenes as always. Are you seeing people signing on?
We have 3 so far. 4.
All right. So the people that are signing on and popping in, thank you so much. Can you let us know that you can hear us in the chat somewhere? Just simply indicate, yeah, we can hear you fine. If not, I want to adjust real quick with the microphone. So can you hear me? That's the magic question. For all those signing in, I feel like if you could hear me, you'd be saying it. So my fear is that you might not actually be able to hear me. Any luck? Oh, someone can hear me. Okay, the volume is okay. You can hear my voice all right. All of that sounds good. Whoever you are, mystery person, thank you so much. I can't see the list that Mario's looking at, so I appreciate that. So I want to give this a few more. Looks like the volume. Are you shaking your head to the volume? Okay, perfect. Good. Hey, we're getting there all right. We're also hoping that by using the microphone, we don't have as much of an issue with any of the typing sounds. If that is still a concern, let us know. We're going to continue working on it. I even got a silent keyboard so it doesn't type as loudly in general. So I will get started on this as some more people sign in, just to give the brief introduction on what we are doing over the next 12 months. So for those who don't know, my name is Anthony DiUlio. I'm one of the owners and partners of Wheeler, DiUlio, and Barnaby. Behind the scenes is my partner, Mario Barnaby, who will be able to answer any questions that you may have behind the scenes and post the questions up here for us to discuss for all involved. One of the most valuable aspects that I find from these webinars and this Lunch and Learn series is the live interaction, so that if you have questions, you can post them to the chat. We can get them put up onto the screen and get your your questions answered right away, so that you don't have to wait around or worry about calling me later. What we are doing over the next 12 months is an entire series called The Perfect Claim. The goal of this series is going to be to focus on the claim adjusting process, what a good claim looks like, what a bad claim looks like, and all of the in-betweens, from literally starting up your business and your process as an adjuster all the way through closing the claim and what steps are necessary in the event that a claim can't be closed. So this 12-part series, we're going to have one every month. We're going to talk about all types of things, understanding the policies, finding claims, adjusting what makes a claim look like a good claim to the insurance companies, really everything that is involved in the process. So today we are going to be starting off right where anybody that starts in the insurance industry should start. It's what you should do before you ever adjust your claim, your very first claim. The insurance industry is complex. It's got a lot of moving parts when it comes to an industry, between what happens in the governmental side to what happens in the field, what happens in the insurance companies themselves, and what happens in your offices. That process can be made a lot simpler if you get into it with the right headspace and understand exactly what you should be doing before you ever even start. So that's what we're talking about here. Before you start, you should know the law and you should know the industry. As always, my information is down here. You can contact me anytime. Days, weeks, nights, weekends, whatever you need. That is my personal cell phone number and my email, obviously our company webpage as well. Feel free to use it. Use me as a resource when you've got questions in the field that you need to get answered. I will be happy to answer them. I'm not always available 24/7. Unfortunately, I'm in things like depositions. I just had to move this, for example, because I was in trial for a week and a half because a rice cooker caught fire, which we were successful on, thank goodness. And those types of moments can make it tough, but I do make it a priority to get back to you within a reasonable amount of time. So please feel free to reach out. You've got that information, and we post it again, I think, at the end of the slides as well. One quick thing, our disclaimer. Not every claim is going to be perfect. I put the slide up here just so we have some text to it, but the general idea is if you don't have a perfect claim, it doesn't mean the insurance company is going to be allowed to deny it. The insurance will ultimately decide based off of the policy, based off of the facts of the loss, whether or not that is covered. So if you don't do something in this 12-part series that I might frown upon for some reason, that's okay. It doesn't mean that the insurance company is allowed to come back and say, "Hey, Tony told you to do this. Look at his slides. Look at his presentation. He said this is what's supposed to happen. It didn't happen. Too bad. You're not covered." That's not the point here. Also, as a disclaimer, I'm licensed in, and as we're going to talk about, Pennsylvania, New Jersey, and Virginia. The purpose of this is not to give you legal opinions. If you want specific advice on something, please feel free to reach out to me or any other attorney in your local area. If I can't answer it, I can find you someone who can. I've got attorneys now almost the entire East Coast. So if you've got something going on, please let me know. And we've now got presence moving out west, so I can find you someone if you need it. So let's talk about what we're going to go over during this lunch and learn. First, we're going to talk about your system setup, your setup for your office, your claims adjusting, what you should be doing to really make sure that everything is in place before you adjust your very first claim so that you're not making the mistakes that I've seen over and over and over again when these claims are ultimately reviewed by me. We're going to talk about organizing that claim within your office itself, what your files should be looking like, how you should be doing that to make sure that things are easily accessible and easy to reference when you need to. We're going to get into the contracts. For that, we're going to hear from a guest speaker, Holly Soffer, who's going to come on in a little bit and talk to you about the contract issues that we are seeing over and over and over again. Holly Soffer is a fantastic attorney when it comes to the behind the scenes stuff that I know very little about, to be honest. For contract drafting, all of your waivers, anything in writing that you've got as part of your claim and your licensing for yourself or your business, she is a fantastic resource and I highly recommend her, to say the least. We're going to talk a little bit about claim laws and the unfair claims practices because it's going to be important for you to understand when you're getting into this industry, what are the governing laws that I have to follow, and not more importantly, but as importantly, what are the laws that govern the insurance companies and what they have to do? Finally, we're going to talk about planning for success, all that miscellaneous stuff that you should be thinking about when you're starting your practice and starting to learn really about this industry as a whole. Real quick about me, because a lot of people form the question, well, why, Tony, should we be listening to you? You're not a public adjuster, and I admit that. But I have seen thousands, tens of thousands of cases at this point in my career. I have been a first-party insurance attorney for 10 years now. I have, like I said, seen thousands, if not tens of thousands of cases. I was a contractor with my father's business before I actually got into law school. So I have done almost everything in a home, short of putting on a roof. I have not put on a roof in a property yet, although I'm actually kind of interested in doing that. For any of you roofers, you want a hand for a day, let me know. I think it's really valuable to have that information. I've framed homes, I've put in windows, I've insulated, I've put flooring down, I've done electrical, I've done plumbing. Having that knowledge as an attorney in this industry has been invaluable to me when it comes to understanding the process, understanding what's being estimated for, and really knowing why the insurance company is so wrong sometimes in what they are doing. Beyond that, I'm the owner of a business, Wheeler, DiUlio, and Barnaby PC. My partner Mario and I are now the full owners, and we've really started to figure out when it comes to running a business, what works and what doesn't work. So trying to use some of that advice for this as well. I also do public speaking events. Obviously, beyond this, a number of you have probably seen or heard me speaking at events for public adjuster associations, but I've also done talks for insurance companies, insurance claims handling on their side when they have their internal conventions. So I've seen a lot, let's put it that way. What I'm not, and I openly admit, I am not a public adjuster. I've assisted in adjusting claims pre-litigation, but I am not a public adjuster. I'm also not a pushover or a sympathizer when it comes to these claims. We're going to talk throughout this entire series about claims practices that can be beneficial. It's something you're going to hear me say over and over again is that you get more honey, more bees with honey than you do vinegar. The reason I say that and the reason I want to make this disclosure, just because I am being kind to the other side doesn't mean I am being a pushover. Doesn't mean they're getting one over on me. In fact, it's the exact opposite, that good relationships with the other side can do a lot towards getting proper resolutions of these claims so that you don't have to come to me. I've said this in almost every talk I've ever done. I don't want you to have to send me a claim. One of the goals of this series is to make sure that you don't have to send claims to litigation. I understand the difficulties that come along with that when it comes to a longer timeline for both yourself and the homeowner to be paid. And I get that the difficulties in lowering your fee, because now you get paid as an expert rather than getting your adjuster's fee on it. I get all of that. So the goal here is to make sure you don't have to come to me. But that doesn't mean that that I'm going to ever suggest you just roll over for the purpose of a relationship. In my eyes, there's really two ways to do this, and there's benefits to all of them. But there's a scorched earth method of adjusting where your way or no way, and you know best, and it's always the best, versus the more bees with honey than vinegar method. They've got benefits. They're both good in their own right, and they've both got weaknesses. But in the end, I have found far more success from keeping good relationships. I also don't know everything. Despite doing this for a long time and having what I would consider a lot of knowledge on this, I don't know everything. So one of the things we're going to talk about here is where else you can go for information to make sure that you have the most successful practice you can have as an adjuster. All right, so let's dive into this. Let's talk about the systems. When you start your systems in your office, either as a new adjuster or an experienced adjuster who's looking to revamp to make things as efficient as possible, you want to make sure that you have the focus on that word, efficiency. Our time is money for all of us. So you want to make sure that when you're setting your systems up, you're doing it in a way that makes that time as efficiently used as possible. The goals here that we're going to talk about are going to help towards that. Yes, some of them cost money. And you're going to have to recognize that there are some costs that you're going to have if you want to make sure you've got a system that is both efficient and able to grow as you will hopefully grow. And the first to that end is a claims software system. Now there's a lot of old school adjusters out there and contractors who are doing some of this work that have systems that have no kind of explanation, no rhyme or reason. They keep files just saved on their computer, and they access one giant folder that has everything, and it just doesn't do the trick anymore. The insurance companies have their own internal systems that they're using, and they use it to their advantage because they recognize that most adjusters aren't. So when it comes to a dispute down the road about, hey, I called you 4 times, insurance company, and here's my log notes, now you can prove with some level of evidence that you actually did those types of things. But more importantly, these systems, these software programs will allow you to have a lot more automation. And automation is critical to saving yourself time and energy on these claims. One of the most important, and by the way, these are just 2 examples up here. We've got Claim Wizard and Virtual Claims Adjuster, both good systems. I can't endorse any specific one. I don't use them, but I'm sure, without question, there are a ton of people in this industry who are willing to talk to you about them. Try to find one that is right for you. But here are the key features that I really, really think every system needs to have. And it's the form letters and the automated tasks. Now, form letters you should have, for example, any claim when it is being notified, you should have a form letter that goes out. And that form letter should indicate some very specific things. Number 1, it should indicate your representation of the insured. It should include the loss that is being presented, including the date of that loss. It should include an authorization that you are to be included on every check that is issued from here on out. It should also make a claim that your insured is making a claim for any recoverable depreciation, and to accept this as notice that they are making a claim for recoverable depreciation. That's just a small portion of things that should be in these letters that should be automatic every time you've got the same thing going out. The reason that's so important, for example, with the depreciation, carriers, a few of the policies that are out there have a requirement to put them on notice of the desire to get recoverable depreciation within 180 days. So if you have that in your notification letter, you've already taken care of that. You've wiped that out without issue. You're good to go. Your claims dispute letters or your follow-up letters should all have citations to the statutes for the insurance company to make sure that they are aware of, so that you don't have to worry about looking up, PA Code 42, for the Unfair Claims Practices Act, and you can just have it automatically in there with, in essence, a fill-in-the-blank type form once you get to that point. These form letters can save an immense amount of time. The automated tasks is the other really important aspect of these systems. So that we're going to talk about the timelines here. You can go in and say, okay, I've notified the claim on X date. Here is my timeline of automatic tasks that will come through to make sure that I don't miss anything. One of the important aspects of this system setup is to protect yourselves. You don't want an insured coming back to you and saying, hey, you didn't notify the insurance company of my recoverable depreciation, now I don't have a chance of it. You didn't tell me that there was a 1-year suit limitation within the policy, so I need to come after you now because you didn't do something you were supposed to do. These systems can help protect you from that. I truly cannot stress enough how valuable they can be. And they're not terribly expensive. This isn't something where you're going to be spending thousands upon thousands of dollars a month just to try and maintain this system. So you need to have those automated tasks, especially when we take a look at the timeline, which I think is the next slide, or 2 slides away. So that's the software that you should be having. Beyond that, you should be having accounting software. This is the no-brainer, kind of an easy one for me to talk about. QuickBooks is the go-to for most businesses. You need to be tracking your money. One of the number one problems that I see coming from adjusters is when the money is not being tracked properly and something goes awry. An insured claims they weren't paid when they were. The insurance company says that you deposited a check that you didn't. Get some accounting software. It's very inexpensive. It can be all online, like with QuickBooks. You don't even have to have the program on your computer. You absolutely should have that. By the way, all of these systems that you have, whether it be claims software, accounting software, or the other things that we talk about, should be cloud-based. You want to be able to access it anywhere you go so that you can make sure when you have to send that quick letter in the car because the insurance company said, hey, we agree to all these things, and you want to get that letter out immediately, you can do it right from your cell phone or laptop in your car. All right, keep going through here. We've got the equipment. Now, I don't know how I have to still talk about this. I've been talking about it for 10 years and it still doesn't happen. The number one thing that you need to have for your claims is a camera. Now, your cell phone is perfectly fine. Cell phones nowadays take incredible photographs, and you should make sure that you are using that lovely feature for your claims. I am shocked at the number of times I get calls from adjusters who say, hey, I've got a great claim for you. Are you interested? I say, sure. Can you send me the photographs? Oh, I didn't take any. They took photographs. I was just going to rely on them. No, absolutely not. You should be taking photographs of every single claim. First, you don't know if you're going to ever get the photographs from the insurance company or the third-party adjuster, so take your own. Number 2, they are going to take photos that look good for them. You want to take photos that look good for you. So please, please, please take photographs of your loss. If you need to know how to take those, you do a wide shot of the area and then your close-ups to make sure that you've got identifiers for any area of loss. If I were to just take a picture of this wall and it only shows me this area, I have no idea where in the room this is unless I get some type of reference point. Hopefully, everybody on this conference is doing that, and if you're not, please do. The other aspect with pictures, check the picture that you took before you leave the house. You should go through your entire reel of photos before you leave, because what I constantly see now is, oh, Tony, I took photos, here you go, and they're moving the camera while they take the picture, or it's too dark and you can't see anything, or the flash is actually too bright and you can't. It's unbelievable the number of bad pictures that I've seen from adjusters on these claims. So please take pictures and make sure that they are good pictures. Number 2, everybody should have a moisture meter. It is number one thing to show that there is actual water damage when you can't see it to walls, floors, and ceilings. Again, a no-brainer, hopefully for most, but if you didn't know it, make sure you get one. The purpose of these items when it comes to the camera, the moisture meter, the thermal imaging, the Matterport, All of this is about documenting a file with proof, evidence that you are correct in whatever you are presenting to the insurance company. If this wall were to get wet behind it and I didn't have a moisture meter or a thermal imaging camera, I could take a picture all day of this wall, but I don't have proof that it's wet. If I put that moisture meter up here and it shows me a 99 moisture, and I take a picture of that, proving it, documenting it, now I have physical evidence that is really incontrovertible by the insurance company. Excuse me. So many of these claims are not resolved because there's just no proof provided by the adjuster. It is absolutely, excuse me, critical that you are able to back up whatever your position is with some level of proof. It is really difficult to go into a loss and say, hey, insurance company, you missed the water damage in the living room. And they come back and say, okay, well, it's been demoed now, so can you show me evidence that there was water damage? No, I'm sorry, I don't have any. Well, how do you win that fight? Right? It becomes really difficult if it's just based off of the words that somebody says. If you have hard evidence, like the moisture meeting, like the thermal imager, like the Matterport photos, you've got a much better shot. So when it comes to the thermal imagers, these are not terribly expensive anymore. There are obviously $1,000 machines out there, but you can get a pretty good thermal imager for about $200 to $300. Certainly good enough for what you need to be doing. I would highly recommend investing in one. They are much more visually stimulating than a moisture meter on a wall. It gives you a much better sense that the water damage to the property is more extensive than what meets the eye. It is a great piece of evidence. The one thing I will tell you is make sure you know what you're doing when you use it. You can watch usually about a 5 or 10 minute instructional video that gives you enough basic information to use it properly, but you want to make sure that you are doing it the right way so you're not presenting something that isn't accurate. Finally, for those who don't know, Matterport, and there's some other companies out there that are doing it now, is a really cool camera that images an entire room. Matterports are expensive. The cameras themselves are thousands of dollars. But if you're a big enough outfit and you do large enough losses, it's unbelievable in doing a claim. What it does, if you can picture a Google Street View, and you can kind of walk down the street by pressing that next button on the map, it does that, but inside of the home. So it does a 360 view, so you can look everywhere throughout the property. They also provide measurements for the rooms. I mean, it's really incredible what it can do. But I have heard that there's really good ones for like iPhone that you can just download as an app for like $100 and do it that way. So whatever you do, look into something. All of these types of things make your job not only better for providing proof, but if it's something like a Matterport or similar program that does the measurements for you, it can save you a whole lot of time too. All right, last but not least, the adjusting software. You need an estimating software. All right, doing it just from what you think it costs in the industry these days is really, really tough. It's not impossible. You absolutely can do it, but estimating software will make your estimates have a little bit more credibility. But it's important. I want to stress this. It doesn't have to be Xactimate. I'm actually on the fence nowadays about Xactimate, and mainly because it's an extremely complex system, and it is a complex system that is designed and paid for by insurance companies. So it's automatically going to have some skew to it. And what happens is Xactimate pricing is confirmed by other people who already use Xactimate, who then use that pricing to confirm it. It's this like cyclical problem within Xactimate itself. But more importantly, what I find is the people that are using Xactimate because it's the insurance estimator aren't using it properly. There are certifications for Xactimate, and if you don't have them, you're probably missing items in your Xactimate estimate. It's unbelievable. If you were to take 5 different adjusters and send them into the identical loss for using Xactimate, they are going to have pretty substantially different estimates. And it's really a question of usage of Xactimate and making sure that you understand what line items are there, what aren't included in any specific item. It gets complex. So take a look into the software, use what you're most comfortable with, but try and find something that will help you in presenting your claims. Finally, aerial imagery can be a real help to exterior claims and documenting a loss. Not only does it assist you in measurements for things like roofs and siding, but it can also provide you the proof. When I say aerial imagery, you can do a lot of this with a drone. If you've got your own drone of decent enough quality, you can image the outside of the house and be done with it. You can also use aerial imagery to look into the past with things like Google Earth. Those can be extremely helpful because if you've got a roof claim where the carrier is saying, oh no, these shingles have been worn and torn and this has been an ongoing problem, you go back onto Google and maybe you get lucky and find an image of the roof from last year. None of the damage is there. Well, now you've got pretty good evidence against them. These are the types of things you're going to want to think about when you're going into adjusting your claims. All right, organization. This is how your files should be set up. All right, this, if anyone doesn't know, is the first line, the first thing that should be in any one of your files when you're organizing it. And what this represents is the year, the month, and the day. So if that's the year, month, and day of the letter that was sent, the year, month, and day of the picture that was taken, the day you received the letter, whatever the important date is, it should be the very first thing. Then you can do an underscore and your item. The reason this is important is because doing it this way allows you to organize your files simply by their date. And I know what you're going to say. Well, wait, they've got a date taken or a date modified on there. But that date can change, whether it be because a file was copied over on a different day, it was scanned in a different day than it was actually received. There's a lot of variables to that date so that you want to make sure you have yours chronologically saved in your system. I know everybody on this thing, well, most people on this thing are going to say, that's a waste of time. I don't need to do it. The ease that this creates in searching through your file when you need to find something to send it to an adjuster is unbelievable. You want to make sure you have your photos saved in one section, letters, your letters, their letters, all of your proofs, whether that be the photographs, moisture readings, all of those saved, estimates, and log notes. If I didn't make it clear before, you should be keeping log notes for your files. Anytime you make a phone call, anytime you speak to somebody, left a message, whatever the case may be, if it's not documented in something like a letter, it should be documented in your log note to make sure that it's happening. Just to make this clearer, here is your file system. All your files get organized by your client name. Within that, your date of loss. The reason the date of loss is important is because hopefully you will have some repeat clients throughout the years. And you want to make sure that you can go back and say, oh, Jane Smith, I did a claim for her in October of 2015. Now here's another date of loss of January 22, and keep those organized separately. And within those, you can separate them by photos, outgoing letters, incoming letters, estimates, proofs, miscellaneous. This is just an example, but it is certainly a much, much more efficient way than what I see when adjusters send me a file and everything is just mixed together. It makes it very difficult to find the item properly. The timelines. The timelines for your claims are really important. We talked about that automation that your systems should be set up with. In here, every single claim that you do should have some level of a timeline. And these dates are given to you by either your own decisions of how long you want to do for documenting the loss, scheduling an inspection, but have it be uniform across the board for your claims. This makes sure that every single claim is being done the same way, with the same correct results, and ultimately getting the best outcome for your insured and yourself. You need not only your own timeline, but a tracking of the important dates. Now, most of this you can get from the Unfair Claims Practice Acts of your local state. It will tell you that they have 10 days to inspect the loss, and then they've got 10 days to provide you a coverage decision, or 30 days for their initial position, so on and so forth. Make sure you have that being tracked. If you're not, I know what happens because I see it constantly. Files take a back seat. And what will happen is you'll be at day 60 and all of a sudden you'll realize the insurance company never sent you their 30-day position letter and you've just lost 30 days of time because now you're sending a letter to them asking for what they should have given you 30 days ago. It can be incredibly, incredibly helpful to have these. So please, please do it. If you have questions about any of these slides, not only can you ask us live right now, but you can give me a call. I will be happy to take some time to go over this in a little bit more detail with you. It doesn't cost you a penny, but I truly do this because I want the industry to be better as a whole. There's too many bad adjusters out there who aren't doing things the right way. If I can help in any way to make this smoother for you and get the correct results, please let me know. Okay, The proper paperwork. I'm trying to keep this as on pace as I can. I'm pretty proud of myself so far. Having the right paperwork in your claim when you start is possibly one of the most important things you can do, because this protects you. Having the correct contracts in line, having the disclaimers, having the correct authorizations, all of these items are things that will protect you in the end, not only from your client, but from the insurance company, from the insurance department, from all of it. To that end, you want to make sure that you're not getting that phone call from the insurance department saying, hey, you're under investigation for X, Y, and Z. Can you send me all of your stuff? And only then do you realize, uh-oh, I don't have the right contract. Or, uh-oh, I didn't have the authorization to sign the checks in my file. I'm going to get in trouble. So, for this topic, we've got Holly Soffer. We're going to pull her up now. Holly is an attorney who practices all across the country, assisting adjusters and their firms in drafting the contracts, in helping with the waivers, making sure that you are licensed properly, making sure the business is licensed properly. I mean, there's so many rules about this stuff that's way over my head. That's why I've got Holly here. Let's make sure we unmute her too, because we've got the computer muted. Holly, can you hear us?
I can hear you. Can you hear me?
You are loud and clear, Holly. So I'm going to turn this over to
Awesome.
you for a minute to talk to everybody just about when it comes to these contracts, when it comes to these authorizations. What do they need? What do they need to be looking for, and how do they get in touch with you if they need?
Okay. Thanks, Tony. Really great information so far, by the way. I've actually learned a few things listening to the earlier part of the webinar. So when you're sitting down with your paperwork, and Tony's brought you to this point very carefully because you're putting in place everything in your file that you need to handle the claim. And at this point, he's helping take care of you. And that's, give Tony a plug. One thing I like about Tony is he doesn't just take care of the clients that you refer to him. He's trying to take care of you as well and protect you. And that's what using the correct documents will do for you. So what I usually specialize in is helping people that are either just starting out or that are working in more than one state. So that if you're going, say you're a Pennsylvania resident and you're going to New Jersey, what do you need to know there? It's not just about the documents, but what about your conduct? What do you need to know that's different? Or if you're going to New York or Texas or Florida. But also, sometimes you need to worry about your own state if you haven't looked at it in a long time. So if you've been a public adjuster for 25 years and you only operate in one state and you haven't looked at your contract or your documents in 25 years, that's not good either, because laws change, regulations change. If you've been paying attention, or if you work in New York, and I don't know who the audience is here, if you're local to where Tony is or all over the country, but New York has changed its procedures recently. We're hoping that New Jersey will. Pennsylvania has a form contract since 2012. Rules change on whether you can use signature authorization forms for clients, and those have become so much more popular since the COVID outbreak, because nobody wants to see anybody in person anymore, and the mail is really, really slow these days. So those forms, if you don't know what they are forms that allow you to endorse your client's signature on the back of the check. Again, only if it's made out to you and the insured. If there's a mortgage company name on it, you can't endorse the mortgage company name. But if it's just you and the client, then you can endorse your client's name to the back of the check if you have this form, and then deposit it in your trust account and then distribute it according to the terms of your contract. And it has to be revocable. And there are lots of other protections that you have to build in. So you need the right form. And if you're already using one, just make sure that whoever's name you are going to put on the back of that check, that you have that person's permission. And please check in with me or with Tony if you're going to use that form, because you can't use it in every state. Texas, for instance, not allowed. And some of the southern states, you need different things to be in there than you do up here, but you can use it in PA, New Jersey. You don't need it in New York because they have direct pay. And they've recently changed some of the rules with that. Before New York, I don't know, Tony, how much you want me to get into the specific states or just in general, but
Yeah.
What I do is I help public adjusters with all these compliance issues. And I also can help you if the state has sent you a letter saying, we received a complaint about you, or we're investigating you, or sometimes these things come up. You may do a great job and your client loves you, but maybe your client filed a complaint with the state against the insurance company, not against you. And then they want to see your whole file to help them investigate the insurance company. And that's when they notice that some of your documents are not compliant, and sometimes they'll go after you for that.
And Holly, oh, sorry, I was just going to jump in because two things I want to make sure I ask you about when it comes to the audience, because they are across the country. People, we've got Florida, some California people. So when it comes to understanding the state-specific stuff, someone that is working in PA, they just want to use the state. They've got a contract that is the state contract. They're okay with it in Pennsylvania. Is it important to know for them, if I'm going to New Jersey, I can just use the same thing, or do they need to look into the specifics of it with someone like you?
Oh, no. Absolutely can't say this enough. You cannot use the same contract in every state. Cannot. Every state has different laws and different regulations. So you have to have a state-specific contract, especially some states have forms. Some states, and I have a chart on this, and I'll back up a little. I'm also the counsel for APIA, which is the American Association of Public Insurance Adjusters. So in that role, if there's ever a proposed change in a regulation or a law involving public adjusters, it comes across my desk. So I'm always up on what's going on. So if I do your contract, for instance, for Texas, and then Texas has a new law passed, I will know about it, or I'll actually know about it before it's passed, but I'll send you a notice once you're in my system that says, oh, something has changed in Texas. We need to tweak your contract or tweak this document or that document. Because once you're in my system, I'll send you an email, but otherwise you may not know, but I know. So if you take anything away from this, it's that you cannot use the same documents in every state at all. And some states like Florida, your contract is your letter of representation or your notice letter. In other states, it's not, they're separate. There are different rules in every state, not just with contracts, but proof of loss, notice letters, check authorizations, all kinds of other forms that you use. And it's also important to know what the law is with regard to, is there a ban on solicitation? Can you advertise there? Does your advertising have to have certain words in it or not have certain words in it? All of that comes into play as well.
One of the questions that comes up all the time for me, and I send them to you, but just so we can talk about it here briefly, what about when it comes to disclosures about involvement in construction companies or remediation companies? Is that consistent across the board, or again, something that's state specific? And can you give some examples?
Yeah, put it this way. If you're not sure, just think it's not. There's nothing that works across the board with regard to insurance in the United States, because it's governed and regulated by states. So every state is different. There may be a few that are similar, but pretty much every state is different. So especially with the contractor issues, I guess that's called sort of conflict of interest regulation, but there's an argument, of course, that it's not a conflict of interest. But whether you can be a contractor on the same plane, whether you can own an interest in a contracting company, whether you can do emergency remediation, whether you can come in, do construction at the end, whether your wife can work, all of those different things, or your second cousin, or you may be a silent partner in a construction company. All of those things vary state by state, and that's something you really have to stay on top of, because those rules are changing. There are different business models in different parts of the country. In Illinois, for instance, public adjusters are often construction companies and contractors, and they're expected to be that by the clients. That's the business model. In other parts of the Midwest, a lot of public adjusters get all of their business from contractors, and the contractors may even pay their fee. And that's a business model that's actually very successful, especially on commercial claims. And then there are states like Ohio that forbid you from having any interest in any type of construction or emergency remediation. You can't even have a spouse. I mean, it has to be zero interest, even not on the same claim. So it really runs the gamut, and that's something that you need to know. And that's something where if you come to me and say, I want to get set up in Illinois, what do I need to know? In addition to doing your documents, I basically give you a document called What You Need to Know, coincidentally is the title. And then it's tailored to a specific company. So if you tell me that you're really, really concerned about this one issue, then we'll tailor it that way. But yeah, I know Tony calls me and I call him, and he's a great resource. But these are the things you need to know to keep you out of trouble. Just like Tony said earlier, he doesn't want your case. He wants you to be able to get a great resolution, and he's trying to help you. Doesn't want to have to litigate every case. I don't want to have to help you when you get a letter from the Department of Insurance saying you did this, that, and the other thing wrong, and you're going to be fined. I'd much rather work with you in advance to prevent all of that from happening.
And what's the best way for people to reach you, Holly?
Well, I guess I should have put up a logo or something, but you can either ask Tony or can go to my LinkedIn or website, and my phone number is 215-244-1045. Someone just designed a new logo for me that's not on my website yet, so I apologize. It will be there soon, and it will be lovely.
And before I put you on, Holly, I did have your slide up here, so they have gotten a chance to see that. I'll put it up again in a moment. But
thanks, Tony. And I can't stress enough that Tony, just by doing these webinars, Tony's showing that he is, again, he doesn't just he's a great lawyer. I know a lot of lawyers, and I can say Tony is a great lawyer, but he also is interested in helping you, the public adjuster, not just doing a great job for your client, but also helping you so that you can do a better job for your clients as well.
I appreciate that, Holly. Thank you so much.
There was one question that came in for Holly. Are there any laws banning public adjusters from handling independent claims work in addition to PA work? Obviously not on the same claim.
Glad that we got that. I'm certainly not on the same claim, but certain states you cannot, again, yes, just like everything else. In a lot of states, you can be an IA, an independent adjuster, and also be a public adjuster. In fact, some of the really good public adjusters that I know are also independent adjusters, but not in every state. So you have to say specifically which states, and then we have to research it. That I don't have a chart for yet. Some of the others, it's a quick answer because I've looked at the issue so many times that I can just look at my chart, which I update obviously, and say yes or no. But that's something I have to look at. I've only dealt with that in a few states.
But if it is something you could do, it would be a great way to add some credibility to your resume to say, look, I work on both sides of this fence. You can absolutely trust me with this. When it comes to certainly later down the road with things like testimony, that would be a nice credential to have. But make sure you check with Holly before you do that, because you don't want to be in violation of the state laws or regulations.
Yeah, it really does help. As I said, I know a great public adjuster who's also an independent adjuster, and it does give her that advantage, especially like Tony said, which is something I hadn't even thought of. When testifying in court, it would give you a great advantage. Yep. And I had just thought about having it give you an advantage on the claim because you sort of see it from both sides.
Absolutely. All right, Holly, thank you so much for coming on. Again,
you're welcome. Thank you for having me on.
Yeah, and I'll put your information back up, and now you can go.
Oh
yeah, go ahead.
Let me just give a little plug. I should have had the title of it. I don't recall the title. I'm doing a podcast with Matt Mulholland. I forget what it's called. Live L2B something like that. That's Tuesday night from 6 to 7. So if you have his name, you can look it up.
Yeah. Listen to this bull.
Topics.
Listen to this bull.
Yeah.
That's what it's.
So it's basically this topics, adjusting in different states. So if you have more questions on that, maybe we can answer them on Tuesday. You can call in live. It should be fun.
Yeah, great. Check it out. If you guys need the link, actually, I was on Matt's show last week, so I've got the link. I can share it with you as well. Holly.
Yeah, he records it, so you can listen to Tony's and go back on and hear the whole thing.
Yeah. All right, Holly. Thanks so much. You enjoy the rest of your day, okay?
Thanks, Tony.
All right.
Bye.
All right. We're going back into it. I want to put Holly's information back up real quick. Again, she works all across the country. Since she's the counsel for APIA, the American Association of Public Insurance Adjusters. I can't think of a state she hasn't worked in. I'm sure if you happen to be in Hawaii, she might take a flight out just to give you some personal attention to it. So wherever you are, give her a call. Here's her information, including her email address and website. And my title for her, by the way, I put this, she does not call herself that. That was my doing, contracts extraordinaire. So let's keep going here because we're running lowish on time. Let's talk about some of those statutes. So when you get into public adjusting and you want to have an understanding as to what some people do or need to do when it comes to the carrier side versus what you need to do, you need to have an understanding of what the laws are. So statutes, codes, these are the laws put into place by the state Congress as to what must be done in any adjusting situation. So there are regulations like Holly was talking about when it comes to your contracts, what you're allowed to do. But there's also regulations as to what the insurance company has to do. And they are often outlined in things like the Unfair Claims Practices Act in whatever your state is. Just so you're aware, that was originally created, the Unfair Claims Practice Act. There was a form created by the NAIC, and they gave it to all 50 states to say, hey, here's a boilerplate for you, adopt what you like, change what you need to, and the states all did it in their own way. You should make sure you understand your specific state. Now, I'm not going to go through the whole thing again. I did a webinar on this. You can go to our website at wdblegal.com, click on the blog, and just search unfair, and it will pop up. The very first thing will be our video on unfair claims practices. Rather than go through all of it, which was an entire webinar of itself, I just want to hit on some of the big ones in here. So, for example, something that you're going to want to know if you're practicing in New Jersey is the carrier must provide this code to all of their employees. The reason that's so important is because you're going to be able to use it against them if they are in violation of the code. So, for example, they're not giving you a response within the 10 business days. You note to them that this is what the New Jersey code says, and it certainly puts them on notice that they are not only messing up, but that they should know that they are messing up. One of the most important things in the Unfair Claims Practice Acts are the governed timelines that are created by the statute. These are the big ones, the 10 days, the 30 days, and the 45 days. Those are generally going to be your breaking points for when certain things need to be done. For example, 10 days, business days to respond to pertinent communications. 10 business days to get out and inspect the loss for the first time. 30 days to give a coverage decision. Updates every 45 days. These are things that are contained within the Unfair Claims Practice Act. That is the timeline guide for your entire adjusting process. This is not used nearly enough by public adjusters because what ends up happening is claims get delayed and they just sit around because the adjusters aren't notifying the carrier, hey, you've got to tell me certain things like, why are the claims being delayed? What's the actual cause of the delay? Not just that it's being delayed or that it's being investigated. What is causing the delay in the investigation? Even better, a lot of them provide that they have to give you some timeline as to when an expectation for a denial or coverage is supposed to be given. So if they send you that letter, and I can't think of a letter that I've ever seen that does this. And where the carrier is required to provide you an expectation as to when their claim will be resolved. I've never seen it. So if they send you hey, we're still adjusting the claim, they need to also tell you in some states, and this is when you can expect an answer. Most of the Unfair Claims Practice Acts actually have a requirement that they provide you the coverages that are offered by the policy. In other words, they have to give you the policy. This is one of my number one complaints I get from adjusters. Oh, I know I'm supposed to have the policy. I know I'm supposed to read the policy, but the carrier won't give it to me. Well, send them a letter with this language cited in it, and you've got a much stronger letter that they should and, well, ultimately will comply with. So what are the remedies if they don't do these things? First, you want to try to avoid the problems. Can't stress that enough when it comes to not only, the more bees with honey than vinegar, but with things like Holly, you don't want to get into the point where you're in a dispute. So we'll talk about this extensively in one of the future lessons, but you want to make sure to avoid the dispute if at all possible. But If you can't, you've got the state as one of your options. You can file a complaint with your own state insurance department under the Unfair Claims Practice Act and have them address it. So for example, carriers refusing to provide a copy of the policy under this provision of the Unfair Claims Practices Act, they just refuse to comply. What will happen is the state should, not always, I admit they don't always step in, but they should send a letter to the carrier asking, why is this happening? And then they'll send you the letter. They won't get penalized or anything, but you've now got your policy when they send their letter of response. The insurance departments don't care about all problems. Generally, they don't care about claim denials. If it's a denial under the policy, you don't really go to the insurance department for that. What they care about are violations of the Unfair Claims Practice Act. Those are the things you want to bring to their attention. Obviously, you've also got the option for litigation. If you hit a wall where nothing else is happening, either a claim is at a standstill, or they've denied it and they shouldn't have, or they've underpaid it, feel free to contact me. I will be happy to help. So, planning for success. The last section of this is what should you have in your back pocket as ways to make sure that you are always up to date, that you are learning as much as you can. First, or what I call the PIAs. These are all of the associations, either locally or nationally, that can assist in knowledge when it comes to this industry. APIA is the one that myself and Holly are involved with. NAPIA is the other national association. There's also a bunch of local ones as well. You should be looking into classes. Knowledge in this field turns directly into success. I really can't stress that enough. The more you know, the better success you are going to have on a claim. That comes to estimating, understanding the policies, understanding the laws. All of it is really critical to being successful in this. Read as much as possible. Go to conventions. Find online groups and forums. I don't know if you're aware of this. There are groups just on Facebook alone, which many of you might have found my post on, so this doesn't go to you, but maybe you're on my email list and you got this. There's groups on Facebook called Level the Playing Field, for example, or Adjuster Attorney Portal. There's multiple ones when it comes to the insurance industry and making sure that you get as much possible information and have people to ask questions of. Again, I don't know everything. I'm not an adjuster in the field, so sure, there is stuff that's going to come up that I might not have an answer to. And turning to those groups is a fantastic way of getting a response. For example, one of the local groups, this is MAPIA. It's the one that I am part of for the Mid-Atlantic Public Insurance Adjusters Association. The group handles all of New Jersey, Pennsylvania, and Maryland, and offers a ton of benefits. You get free CE credits, you get holiday parties, which we just did recently, which was a ton of fun, drinks that are involved, live Q&As. I mean, it's really invaluable, not to mention you're supporting the industry because most of these groups, including mine, retain lobbyists to make sure that we're pushing against the infinite pool of money that insurance companies have when it comes to lobbying the Congresses, state Congresses for new legislation and laws. Really, really important. I recognize that in this industry, we feel like we might be enemies with other public adjusters because we're all competing for the same work. When I say we, I mean, as an industry. The truth is there is enough work for all of us. And the insurance company is really the enemy. I don't want to say enemy because they do sometimes do good things and the right thing, but they are the side that we need to push back against when we see these wrongs that are happening. And if we do it as a whole, if we do it as an industry, we will be far, far more successful in pushing back against them. The literature on this topic of insurance is endless. I mean, it's unbelievable the amount of stuff that's out there. So I put together 6 books that you should read or have in your library and absolutely should be reading as part of this. When Words Collide is a great book. Bill Wilson is incredibly knowledgeable about this industry and does a great job explaining policies, has taught me a ton of great stuff. Never Split the Difference is an amazing book on negotiations that I always recommend to people. And a book that even I didn't know about until a few years ago is the Dictionary of Insurance Terms. When there's a dispute within a policy as to what something means, it's the first place I go to look. A few more when it comes to this industry. This first one is more about running a business than it is about insurance. It's called the E-Myth, and this is the revisited, the revised copy. But it is great when it talks about trying to understand how to set up your business to be successful. Delay, Deny, Defend, and From Good Hands to Boxing Gloves are also great resources for an understanding of the industry. This book, From Good Hands to Boxing Gloves, explains why insurance companies have taken a turn to denying more claims and underpaying more claims, because what it ultimately talks about is insurance companies did a study that they will spend less money on litigation costs than they would actually paying claims. So let them try to litigate. It's really a great study. And Jay Feynman is a professor over at Rutgers who wrote this Delay, Deny, Defend. Again, an amazing resource for the industry. These are all the things you should be having and not just be complacent with your knowledge in this world. All right, so some of the questions that came in. If you guys have questions about stuff we've already talked about, feel free to ask Mario. I know he's typed some of these in already, so let me know if you've got anything else you want us to cover. What do you consider to be good proof in a damage claim for a property loss? Well, number one, your pictures and videos. A walkthrough of a property, either via video or via picture, is invaluable. There is a reason that the old phrase out there is a picture speaks 1,000 words. You can tell a lot more with a photograph than you can with just the words that you're speaking. So having good photographs, having a video walkthrough is amazing. On top of that, having anything that actually shows the proof of damage within the photo is great, like the moisture meter or the thermal imaging camera. Those types of things can make a difference because, again, you can't see all of the damage to this wall just on its face. There might be stuff going on behind it. The number one thing I would complain about in photos and videos that are provided by adjusters are on smoke and fire claims. When you have a smoke loss, there's a tendency to just go in a room and take a picture and say, oh, everything's got smoke on it. The problem with that picture is everything has smoke on it, so it all looks the same. You can't tell that there is smoke on it. If you have a smoke loss, please take a chem sponge, hold it to the wall, take a picture before you wipe it, and then, take a picture after you wipe. Go in and remove a photo from the wall, right? If I were to take one of the pictures in this room off after a smoke loss, there's a good chance I'm going to see the outline from where that picture was. Lift up items off of desks and tables to show all of the soot that is around it, because if you don't do that, you're not taking a good picture of smoke damage. It's really hard to see in a picture. So you want those types of things to actually document the loss. So it's not just about photos, it's photos that actually show, the damage. On top of that, the other big thing that we didn't talk about was independent experts. If you can get a roofer out to a property where you've got wind damage to write a report that says, the roof is X years old and it's got, wind damage here, here, and here. Here are the photographs of it. And as a result, this is the repair that needs to be done. That is a fantastic thing to have to show the proof of the damage. Getting a plumber involved to show this leak was not something that was going on for weeks, months, or years, but based off of my experience, only recently broke. Carriers have a tendency to just lock in on the worst piece of evidence. For a plumbing loss, they might see rust somewhere. Well, your plumber might be able to come in and say, well, no, there's going to be rust on that pipe because of the condensation. That has nothing to do with the damage. What ultimately happens is it breaks that pipe at some point, and that's what causes your loss. Or you've got a plumbing loss that has some rot involved. Oh, that rot actually was from a loss 25 years ago, or I don't know when that rot is, but it's not from this, and here's how I know why. Rot's not, no insurance company dates rot. So as far as I understand, it's actually impossible to accurately do to date any kind of rot. So you can go in, have your report and say, look, you want to look at that rot just because it got wet, but that's actually old, and all of this new damage is what's covered. Those are the types of ways you want to think about documenting a loss to make sure that you've got a good coverage position. We'll talk about this in future talks, but getting that proper evaluation from the get-go before they deny the claim, before they underpay it, is invaluable. Setting things like the reserve, making sure that that's as high as possible, will make your life easier, and we'll talk about that in future talks. All right, what can public adjusters not do in regard to the unlicensed practice of law? When do public adjusters cross the line? We'll take these in reverse order. Too often, they probably get close to the line. They don't cross it very much. But what you generally want to do is you don't want to tell the insurance company they are violating the law, right? As soon as you make a determination that they violated the law, you're probably in the realm of risky, unfair practicing law. What you can do, on the other hand, is provide them citations to the stuff they already know, those unfair claims practices, and simply say, as you're aware, the Unfair Claims Practices Act says X, Y, and Z. You owe me a response within 10 days. And then you say after that, I sent a letter on X date, you haven't responded since then, please provide a response in accordance with the above. You're not practicing law, you're only telling them what is candidly public knowledge and stuff they already need to know as part of the industry. What you really just don't want to do is make that claim that they are in violation of it. That's where it starts to get risky. If you're ever questionable, just talk to an attorney. I'll be happy to walk you through a letter or even write a letter for you and send it from my office to make sure that no lines are being crossed. What are the effects of current Florida legislation on homeowners? Well, this is a big one. Florida legislation came down recently, changing a bunch of laws when it comes to the contractors, public adjusters, and attorneys. It's extensive. I could do probably an entire hour just on the new regulations from Florida. Here's the big takeaways. Contractors are limited in what they're allowed to solicit and how they're allowed to solicit for making insurance claims. The public adjusters now have to, and the homeowners need to provide notices to insurance companies for things like when they're going to litigate, and there's new timelines on suit limitation clauses and putting in claims. As for attorneys, attorney fees have shifted in how they get paid from a straight fee shift on all breach of contract to shifting based off of the amount of recovery in conjunction with what was previously paid. So in essence, if you only get 10% more on a loss, your attorney fee is a lot smaller than if you were to double or triple the amount that was recovered. Those are the biggest takeaways. Very broad, very general. I get that. We just don't have enough time to go through all of them. If you've got a specific question on it, please feel free to give me a call. How do I build and document a case that will stand up against any motions to dismiss? Well, my only problem with this question is the word any. There is no guarantee in the world of courts and judges. They can come in and make decisions that are completely flabbergasting to me because I don't understand where they can come from. But just like we talked about what proofs make a good claim, the exact same is true for how to hold up against a motion to dismiss. When it comes to the legal side of things, the most important aspect for this is that you are actually providing an expert report. That becomes one of the biggest contentions with the court when trying to review these motions, because what happens is if there's no actual report from the expert, they come through and say there's nothing in dispute, there's no evidence that there is a dispute, and the case is tossed early on. This applies for motions to dismiss or motions for summary judgment that happen later on, but you want to make sure that you've actually got a report that says, here's the cause of loss, here's what the policy covers, this is why this loss falls under that, and if you're really good, you'll also add in, this is why the insurance company's position is wrong. So that would be the perfect report, but you at least want to have in there the cause of this loss, the coverages, and why this applies to that loss. Can a carrier legally refuse the appraisal process? Now, this is also a bit of a loaded question. By the way, I recognize not all of these have to do with the topic, but I always try to address questions that come from you guys so that you make sure you feel like they're being answered. Legally refusing the appraisal process is tough because there's a lot of qualifiers in here. Here's what I can tell you. In the original appraisal language, from what you guys know as the HO3 policy, there is a appraisal provision that's about 2 paragraphs long, and it is pretty strict onto what it requires. It requires a dispute as to the amount of the loss, and it requires that it be demanded by one of the parties. That's about it, right? As long as you've got a dispute as to the amount and you've got a demand, you're going to appraisal. What has happened is it's been litigated to death with the courts, and some states have said things like, oh, well, scope's not appraisable now, only amount of damage is. Or other states have come back and said, hey, as long as we've got a covered loss, everything's appraisable, it all goes to appraisal. What carriers have started to do have started to change their policy. So if you go to Farmers, for example, they've got a 3.5-page appraisal provision with a litany of issues with it, none of which have been really resolved by the courts yet. So It's difficult to answer this question in any straightforward fashion because it's going to depend on so many factors. If, however, you've got a claim that you feel there's a dispute as to the amount of the loss, you've made a demand, and they're just saying no, give me a call. We'll be happy to discuss it because there might be a good avenue to make sure you can get that done without even having to worry about the full-on litigation. Okay, this one, a bit longer, but insurance adjuster changed the peril of wind, rain to hail and date of loss to a year earlier from what the homeowner stated. How to change it when the insurance company adjuster refuses? Question mark. He says he was trying to help the client, but they won't cover the inside water damage. Thank you very much. Well, you're welcome very much. The short answer here is you need to put it in writing to the carrier of their unilateral mistake. They don't get to determine the date of loss. The insured does. It's put in as the date of loss for the claim. If they want to come back and say, sorry, there was no damage from that date of loss, that's the risk you run, but they're not allowed to make that change. If they refuse to do it, I would send a letter to the insurance department with my complaint indicating that they've unilaterally put in a claim for a different date of loss that you never put in, and it was for what in essence was your date of loss for a year later. That is something that I believe the insurance department would be interested in. If they aren't, if they don't make any changes, that's when you would give me a call and we might have to litigate that one because there's not much you can do to force anyone's hand on the carrier side. If they just say no, they say no. It's equivalent to, you having a contract to purchase, a truck from somebody, come to a deal, you give them their money and then they never deliver your truck. There's not much you can do to force it without the court's intervention. It's not like you can go in and steal the truck away. All right. In O&L coverage, does the insurer have the duty to inform the insured of the coverage and pay the amount they will pay? I should read these before I copy and paste them. So generally, I think what they're saying is, does the carrier have a responsibility to inform the insured of the O&L coverage and the amount that they're going to pay? Under the Unfair Claims Practice Act, the answer is most likely yes. As long as your state's Unfair Claims Practice Act indicates that they have to provide the coverages to the insured, they have to notify them of the coverages, they have to do the first part. As for the amount they will pay, you can have that in agreement ahead of time so that if they have to go stay at a hotel, everyone's in agreement before those costs get incurred. They don't have to actually pay it. Ordinance law. I was thinking ALE for a second. With the O&L, you can have that agreement before it's actually incurred because it is an incurred expense under the policy, at least most policies, but they don't have to, there's no requirement that they issue that payment ahead of time. I would argue that they'd have to make an agreement to it because otherwise you're going to put the insured in a position where they're spending money that they might not get back simply because the carrier is refusing to do their job. All right, there was one other. How do I get more from insurance adjusters? I saved this one to the end because it kind of made me laugh a little bit. I do recognize the obvious desire to maximize the value of a claim, not just for adjusters, not just for you, but for your property owners. I want to make something clear from my perspective and what should be your perspective. Our job in our industry is to make sure that the insureds are getting what they pay for under their policy. That's it. That's what we are responsible for. We're not responsible for making sure they get enough to cover deductibles or to do extra work in their house or upgrade things. They get what the policy owes for. Now, what they do with that money is their free will. They can do with it as they choose. They may risk recoverable depreciation, but how they spend the money is up to them. Our job is to make sure they're being paid what they're supposed to under the insurance policy. So when you talk about getting more from adjusters, I'm going to take it to mean, how do I get more of what is owed under the policy from the adjusters? And to do that, you're going to want to do the things we talked about here. You're going to want to tune in for the 11 other talks that we have, because all of them are going to be focusing on different areas of adjusting to make sure that we maximize what the policy owes for the benefit of the insured. There is no one-stop shop answer for this. Unfortunately, there's a lot involved with adjusting. That's why we're doing this class. But ultimately, we want to make sure that we understand these policies, we understand what the insurance actually owes for, and we fight for it. One of the other issues I constantly see are adjusters who just give up on the fight too early because they don't want to deal with it. They want the fast turnaround, the quick money. That's not our job in this industry. Our job is to help these homeowners. We are their line of defense with insurance companies that often are trying to take advantage of them not knowing things. So we want to take the steps to protect them. That's what our job is. All right, last, I just need to click in. Last one that came up. How can the insurance company refuse appraisal when it doesn't state that it can anywhere in the policy? I'm not saying they can. I don't believe they can just refuse appraisal. What we're seeing a lot of, and what we've been very successful on in litigation, is when an insurance company refuses to go to appraisal because they make some ludicrous statement like, oh, well, we need more information. We want to keep adjusting the loss. Too bad, right? It doesn't matter that you want to keep adjusting the claim. We've got two disputed amounts. We've got to go to appraisal. I've made the demand. It's not a question. It's a demand. Adjusters often say that they're making a request for appraisal. That's not a request either. It is a demand. And you want to make sure that that's clear for the insurance company. If they refuse to do that, and you say, look, it's either we have to do this or we're going to have to go to litigation. We've been successful settling those with bad faith on bad faith claims because they've got no justifiable reason to force it into litigation to do what they should have been doing from the start. Where it gets difficult are adjusters, which I've seen, for example, who demand appraisal but never give the carrier an estimate as to what they think the loss is. Well, just because you're not happy with what the carrier is paying doesn't mean there's proof that there is a dispute into the amount of loss. So you've got to provide them an estimate, either from yourself or a contractor disputing it. You need to know the laws when it comes to things like New Jersey. The insurance company has to provide a contractor to do it for the amount that they stated in their estimate. If they can't do that, they're forced to increase their estimate until they can. So you want to make sure that you've got those types of things in your back pocket so that you're maximizing it even before it has to go to appraisal. But if you've got a dispute as to the amount and they just don't want to go, they're going to be in the wrong there. Thank you, everybody, so much. Really can't appreciate what you do on a daily basis. And if you guys have questions, here's my contact information. Again, I have this still as Anthony, but you can call me Tony. My cell phone, my email address, and my website. Any other questions, please let me know. And if you guys have any comments just about how this has gone, something we can do better or something you'd want to see in more of these talks, I want to know that as well. I hope I hear from you soon. Everyone take care. Have a great day.